afternoon. My name is Guillermo Patino, the chairperson designee of the New York City Loft Board. I want to introduce our new board members, Linda Resnowicki, our new owners representative, and Lenny Singletary, a new public member. To our new board members, our returning members, and the members of the public, welcome to our September 19, 2024 public meeting. Section 282 of the New York State Multiple Dwelling Law establishes the New York City Loft Board. The board is charged with overseeing the legalization of interim multiple dwelling units, from commercial and manufacturing spaces to legal residential units that comply with the minimum standards of safety and fire protection in Article 7B of the New York State Multiple Dwelling Law. To achieve this goal, the board adjudicates and mediates disputes between owners and tenants, tracks the progress of legalization, and prosecutes parties who violate the Loft Law and the Loft Board's rules. First, turn to vote on meeting minutes. We're going to table the vote on the minutes for the April 18, 2024 meeting. Next, we'll turn to vote on the minutes for the June 20, 2024 meeting. Are there any corrections or comments to the minutes? Can I get a motion to accept the minutes? Thank you, Ms. Rosamond. Can I get a second? Thank you, Mr. Delaney. Ms. Rivera, can you please pull the board members?
Ms. Resnowicki.
Abstain because I wasn't here.
Mr. Barber.
Abstain.
Mr. Wong.
Abstain.
Mr. Delaney.
Yes.
Mr. Secretary.
Abstain.
Ms. Rojan. Yes. Ms. Roseland.
Yes.
Chairperson Patino.
Yes.
4 in favor, 4 abstain.
Thank you.
What was that? How many?
We'll next turn to vote on the minutes from the July 20, 2024 public hearing. Are there any corrections or comments to the minutes? Is there a motion to accept the minutes? Thank you, Mr. Delaney. Is there a second?
I can second.
Thank you, Ms. Rajan. Ms. Rivera, can you please pull the board members?
Ms. Resnowicki.
Abstain.
Mr. Barber.
Abstain.
Mr. Wong.
Abstain.
Mr. Delaney.
Yes.
Mr. Singletary.
Abstain.
Ms. Rojan. Yes. Ms. Roseland.
Yes.
Chairperson Patino.
Yes.
4 in favor, 4 abstain.
Thank you. Next on the agenda is staff reports. First,
Why did we table
when we have Mr. Roche, we'll have the members pass those meeting minutes.
Why did we have the April, the May, the June under one order? Why did we have the minutes of the May and June under one order? Did I not hear it correctly?
No, we had April, June, and July all under separate orders, under separate votes. No. Mr. Rush needs to attend the meeting. Right. Next on the agenda is our staff reports. First turn to the report of our executive director.
Good afternoon, everyone. First, I'd like to report about personnel. First, I welcome Estefania Ruiz. She is our law intern. She will be with us until November. She is L2, grade at Brooklyn Law School. We have reposted the job notice for a legalization attorney. I encourage anyone who is interested to apply. Litigation, we received one Article 78 in August. The case involves a building at 79 Lorimer Street in Brooklyn. We are working with the law department. Included in the materials for today's meeting, we provided a list of the buildings in the law board's jurisdiction. Right now, we have 305 buildings. To summarize the highlights, the first group we have are the buildings in the pre-construction phase. They're the blue piece of the pie. We have 83 buildings and 27% of the buildings in this group, which means that this group includes owners who have not filed an Alt-1, who have filed the Alt-1 but have done nothing else. And the group of buildings narrative statement process, or buildings that have completed the narrative, received the cert, but have not obtained a permit. And then in the blue box, I've broken out the number according to each category. The second group, which is the orange color, are the buildings in the construction phase. Yes.
The seven, of the 7 buildings that have no all one filed, do you know the answer? Are those recently covered buildings? Do they go back to the 80s? Is there a mishmash?
Mishmash.
So there are some buildings that have been covered, but nothing has ever been done to them for 40 years.
The second group are the buildings in the construction phase. That's the orange piece of the pie. The number of buildings in this group is 118, or 39%. That means this group have permits to do the actual legalization. Third group, the gray group, are buildings that have reported that are 70 compliant. We have 71 buildings in this group. I have concerns about the buildings in this group. We have approximately 40 buildings in this group that have noted their 70 compliance by way of a certificate from an architect, not a TCO issued by the Department of Buildings. Some of these certificates are old. At least one of them dates back to 1999. In my opinion, the rule that provides for a certificate by the owner's architect should be revisited. The process of the department has improved vastly. Inspections can happen within days. I recommend that the board consider changing this rule. The last group, the last piece of the pie, the yellow piece, are buildings, 33 buildings, or 11% of the buildings in our jurisdiction. This group has either achieved compliance or there's a removal application pending without a C of O because the owner has decided to convert back to commercial use. The staff is reviewing the fees in section 211 of our rules, of Title 29. Some of these fees have not changed in many years. We believe it's time to look at these rules and determine whether these fees are still appropriate. In some instances, we believe that certain functions should include a fee. For example, the RGB filings have no fee. As evidenced by the removal case on today's agenda, RGB filings can take a considerable amount of work. We're also considering adding a fee for no requests, letters of no objections. And no requests are owners file requesting for approval from the Loft Board to do non-legalization work in non-IMB space. We're also looking at the protected occupancy rules, taking a look at those to see where possible changes can happen there. As mentioned earlier, the rules governing the certification of Article 7B should also be reviewed. Should we eliminate the option given the improvements to DOB of allowing owners to file a certificate? Or should we have certificates expire within a certain time, like temporary certificates of occupancy? Or we can say that if within a certain time the owner doesn't get their CFO, that the certificate expires. The staff is interested in exploring these issues and hearing your thoughts. If you agree that we should consider these rules, we ask that you vote today for the staff to initiate the rulemaking process.
What did we just move in second?
Yeah.
Is that what you're asking?
Well, yes, I mean, in terms of, so we don't have anywhere on our agenda, maybe we should make a motion to add a line item to the agenda at the end for new business, because, that's how other boards and whatnot function. Because this does come up, this is not the first time it's come up where we want to do something when we don't know the plan.
Yeah, I agree.
Well, after, back to the Loft Board staff to pursue, pursue everything that Martha just described. Yes, all of that.
My motion simply was to accept the staff report's recommendation to begin the work, to come back to the board with final instructions.
And that's what I said.
All right, so can we take a vote on that motion? Mr. Rivera?
Vice President Lewis.
Abstain.
Mr. Byron.
Yes.
Mr. Wong. Mr.
Yes.
Yes.
Chairperson Patino.
Yes.
6 in favor, 2 abstain.
Where the fees are appropriate. We're looking at new fees for budget filings. Loan requests. We're looking at revisions to the protected occupancy rule. We're looking at revising the rules regarding certification of Article 70 compliance.
Just to clarify, for members of the public, the motion that we just made was to direct the Loft Board staff to revisit certain rules, so existing rules pertaining to fees and whether those fees are appropriate, considering whether any new fees should be incorporated into the rules, particularly around RGB filings and photo requests. The staff is going to be looking at the protected occupancy rule as well, and then the rule pertaining to certificates related to Article 70 compliance. So we'll come back to the board with recommendations at that future date. Next on our agenda will be Ms. Story to present a legalization report.
Thank you, Chairperson. The September 19, 2024 enforcement/legalization report is as follows. Sorry about this, guys. We have issued 24 administrative determinations over the summer, 20 imposed fines ranging from $1,000 to $2,000, and 4 were withdrawn because the owner actually complied. With regards to the legalization report, we conducted 28 narrative statement conferences from the end of May to mid-September. We have 17 narrative statements scheduled between the end of September and early December. We have 1 request for a narrative statement conference pending. We continue to appreciate the help of all professionals throughout this process. In closing, I would like to thank and send a special thank you to all 4 amazing staff members we have who worked tirelessly, can't get the word out, behind the scenes to help me with the enforcement and the legalization. First is Miss Martha Cruz, Miss Amara Hyde, Miss Tracy Rivers, and Miss Rosa Vargas. Thank you so much for always lending me a helping hand, no matter what the task. Thank you all.
Just one quick question. You got a lot of your state conferences done over the summer.
Yeah, they,
We've been busy.
yes.
How were we able to do it?
Double booking.
Double booking them on the same dates. Some Miss Cruz was able to do by herself. I was able to do by myself. And we got it done.
Are most of them virtual now, or are they?
Yes, majority of them are virtual, but there's still a few that want to come in person. We provide a conference room for them.
Great.
Approximately how many people were present in the July spoke here? Because I only saw 3 comments.
Oh, you talk about the public meeting?
Yeah, public meeting.
Oh, yeah, we're gonna get to that. That's nice. But only 3 people to answer your question.
Now turn to
I'm
discussion.
sorry. How are we doing in terms of registration?
We're still doing our buildings we got through and they have registered, which is, it's a lot of that.
So we have this
We're still going through it.
got it.
But when we find out, you'll probably see some at home.
Well, now turn to discussion of the proposed amendments to Title 29 of the Rules of the City of New York, Sections 204, 205, and 211.1. Ms. Cruz will start the discussion.
I just want to go through some of the changes that we've made since the hearing. Some of the changes were part of the comments we received. Some of them people who testified. Mr. Roche from FDNY came in and we had a conversation about it. Ms. Roslin, I'm sure she will share her thoughts about some of the issues that she's also raising. She let me know that she has some concerns. Okay, but I just want to go through the red lines in the draft that I sent over. So on page 2, we added some information or some description about what is a defect to the fire escape. On page 3, there were 3 changes. FDNY requested that we added straight to C. So the proposal is the fire escape must be straight and painted. In K, we added the word obstructed. So it should read the egress by fire ladder must lead to a court or yard with an unobstructed path to a street. That's page 3. Page 4, we added the requirement to serve all of the tenants. If the owner did not know, if there were personal items in the hallway and the owner did not know who those items belonged, that they would serve all of the tenants on the floor and post the notice that the items had to be removed near the items themselves. We requested a copy with proof of service to be filed with the Loft Board. We added language about no battery charging devices must be stored near an exit. That was a FDNY suggestion. On page 6, we added about certification. The certification that the owner has inspected the fire escapes. So we are right now going through creating certification that the owners will file. and a lot of other questions came up for us. So if their certification says that the owner found a defect, that whether we wanted them to tell us that they found a defect, and require that they fix the defect within 30 days. Do we want them to recertify to us that they've cured the defect and it's now defect-free? And I put in August 6th, which is more than 30 days, slightly more than 30 days from when they were supposed to register with us. So this is all up for grabs. These are all things that sort of came up in our discussions with staff when we were doing the certification. What do we want the response to be? If, of course, if there's no defect, the owner will just fill it out, send it in, and say there's no defect. Right? But if there is a defect, what's the procedure for them to fix it and let us know that they fixed it? Do we want them to let us know, and do we have to give a time frame by when they have to do it? And I don't know if 30 days is sufficient time, but considering what we're talking about here, I think it's a lot of time. But it's your decision to make, and let us know what we should put here.
This is a timely place to bring up the one written comment about the timeline for certification, inspection certification, the 14 days. I thought that was an interesting comment from the public. I apologize, I just got it.
When we drafted the rule, again, we wrote the word structural there. But I don't think that we had envisioned that there would be a bunch of engineers going around to our buildings. What we were really looking for is for someone to go onto the fire escape or to inspect the fire escapes to make sure that they're not coming off the side, right? That there aren't rust, that there aren't problems. We have seen literally facades where fire escapes are compromised, the steps are compromised, the structure may be attached to the facade, but the stair is compromised. So those are the types of things that we were thinking when we drafted that. We weren't thinking that the owner would have to hire a structural engineer to go out to make sure that the fire escape is in good working condition. We wanted to just make sure that either the super or someone from ownership went to the fire egress, fire escape, or the indoor stairwell to make sure that their stairs are not compromised, there aren't holes, which we've seen. These are all things that we've actually witnessed.
But if someone owns a building and has owned it for a significant amount of time and is going through this process, and the fire escape is falling off the building, what do we think this will change in that person's mind? I see the structural engineer as being an integral part of the inspection process. I mean, are we thinking that just by making this a rule that someone will look up and go, oh crap, the fire escape's falling off? I never noticed that in the 20 years I've owned this building.
We've actually had people say that. We've actually had people say, I had no idea this was such a problem. I've heard people say, I'll do it during the negotiation, which is my personal because that's not the right answer. So this rule, I think, highlights the problem, and it gives us the authority to go in and say, no, you will not wait for negotiation. And if you decide that you don't want to, then we're going to start enforcement proceedings against you. It's just like heat. It's just like all of the basic running water, secure front door security. That's what we want to do, is introduce this concept that fire egress is just as important as the basic housing maintenance 10 items that we have in 12.4A. And this is your responsibility to maintain. You have to have someone walk through the fire stairwell, make sure it's thick, make sure there are no broken steps, make sure that there's no rust, make sure that handrails are correct and not falling off, make sure that people can exit your building safely in case of emergency. That's what it is. And to give us the authority to say, if you don't do it, we have no authority to force it against you. Because right now, we don't really have the authority to do, not in-house. Any other questions or concerns?
I have some concerns. I think together with the school, there has to be a notice or an informative pamphlet or something to educate, or maybe not educate, but notify tenants that there are things they shouldn't be doing for their own safety, like putting illegal gates on the windows that open up the fire escape, putting flower pots on fire escapes, putting things in the hallway like bicycles, baby carriages. Even a welcome mat could trip somebody trying to escape in the event of a fire. And so that the tenants also have some responsibility about these things. And I also have a problem with landlord having to, the owners having to hold items for tenants. That is, after tenants have been notified about what they should and should not do within a certain period of time, 30 days, 60 days after a notice that would be drafted by the loft board, then owners should just be free to discard items that are not stored properly in the hallway and not have a duty to store items. I think that takes on an obligation. They might be storing very valuable items, bicycles. I see every other woman I see wears cowboy boots now, spending $500 or $600 on them. So I don't want owners to have that responsibility. And I would like tenants to be informed of their responsibility. And I also don't want owners penalized for what tenants do. I think tenants should be penalized for what tenants do after tenants have been notified. Those are my primary concerns.
I would like to respond.
I think that within the last several months, I think notices have been sent by the building to buildings about stuff in the hallways and things like that. So I think those buildings, basically, they should all be covered with notices.
It is certainly our
Now,
intention.
the question is, who's to be penalized? Is it illegal stuff in the hallway? Or fires? I think the question is who should be penalized if the tenants put illegal things in the hallway or fires. I mean, that's another question. But I think everybody should be aware of this, that the city has made an effort to inform loft tenants of what's legal and not legal about the hallway. I don't know about the fire escape.
So I had some
I don't think it's building
questions.
with a fire escape.
Some questions similarly, and being that I am presumably, all right, here was my question to myself. So loft tenants have signed a commercial lease. So we know that in rent stabilized buildings or rental leases always include dumping stuff in the hallway. That's a really standard lease. So then I was wondering, okay, but a loft tenant would have signed a commercial lease, and I was wondering if the same provisions were in the commercial lease, since I'm the one who signs my lease for my company. I pulled it out, and sure enough, there's two things in my lease. One, it says I can't obstruct the street or the sidewalk or the hallways or the stairs or anything like that. It's in the lease. It's in the boilerplate part of the lease. And then the second is in the rider that any fees or violations or fines incurred by the owner because of something that I've done, I'm responsible for paying. So those are the lease agreement items. And I will say that our building functions very, very well. We have this issue a lot of people leaving stuff in the hallways. The building owner comes, he puts a sign up, and he says you have 30 days to move this. Sometimes the tenants move it, sometimes the building owner, the super, removes those items. It's clean, clear, nobody keeps stuff. You know, it's just about the relationship between the tenants and the owners, and following the rules. It's not, I think it's pretty common knowledge that you're not, it doesn't matter if you're a commercial building, a manufacturing building, a residential building, rent stabilized, not rent stabilized, you don't leave your stuff in the hallway. Co-op building, rental building, it's illegal to leave stuff in the hallway, it's illegal to leave stuff on the fire escape. I realize that people don't know this, but really ignorance of the law is not an excuse. And it's in the lease, it's going to be in the lease. So I don't have,
I just wanted to finish what I was started to say earlier. It is certainly our intention, once this rule goes into effect, that we send notices out to everyone, owners and tenants, every unit in our system, to say to them, this is our rule, and you cannot maintain any personal items in the hallways. This is a common thing in most buildings. This is common, it's not uncommon. So it will be information for people, so I know that this type of notice is necessary. And one pager, it says you cannot have personal items in the hallway, or any hallway that you access the street. That's my opinion.
I think that my understanding of loft buildings, that outside of the front door, let's say an elevator, and then there's a door to the, generally there's a separate, that vestibule. Building is much, much larger because there's a hallway down, probably then into the basement. And I don't know whether it's clear that that vestibule on the first floor where the stairs are, where nothing is allowed to be in there as well. It doesn't seem to be regulation.
yeah, except, Elliot, you're renting a space. The public halls are not your space. You're sort of allowed to use them in shared space. You're only supposed to keep stuff in your apartment. I understand, look, I have pots in my fire escape.
Well, my
I have a
question
little
is-
garden. I'm not saying,
My question
but
is-
I know,
My question
I
is-
know it's not allowed, and I do it anyways. But the point is, I guess I don't feel like we have to defend this because it makes sense, it's logical. People should know it. It's in your lease, it's the law, it's like, We shouldn't have to argue that this is a good idea to tell people not to put stuff in the hall. I guess that's my own.
Yeah, but I'm not sure, did we really resolve the points of the new income standard?
I don't think altogether. I think one reason to notify tenants is, one, for their own safety. You shouldn't do these things in case you didn't know. But two, so that an owner could be free to say, well, somebody left their shoes, their cowboy boots out here, I'm going to take them away, and I don't need to store them anywhere for this tenant. I don't want to be responsible for storing things. Now, you know, the rules now say that landlord basically could dispose of them in 60 days. There's an implication that landlord is obliged to store them up to 59 days. It doesn't say that, but what else could it mean? I just think owners should be free to just clear the hallway after tenants are notified, preferably by a loft board mailing. And the mailing should also say, and if you don't comply with this within 30 days, 60 days, then your owner is free to just clear the hallway. The end, they're gone.
I don't necessarily disagree with you, but the owner very often is not in the building. The owner may be elsewhere most of the time, in their office, maybe not necessarily in that very building. So what it is every building is required to have a super. So the other thing is the responsibility of the super. Not necessarily the owner. Not even know that this occurs. The super would know.
The owner's agent, when I say owner, I'm talking about owner's agent, anyone working for the owner.
Yes, so right now you're giving them 10 days to remove it. If it's not removed within 10 days, you have to store it for 60. So. It's the question.
So, are we going to vote on the question, or you just asking for me?
Well, I'm asking for, I want to.
The next step for this will be in order to for it to publish final and it will go into effect in 30 days. So this is there, what else that there that can be done. So
Is there a separate vote on this one? Or are you asking for a vote on all of this?
if you have to resolve this, what else that can be done, and then potentially at this meeting, we can go to publish the final and it will go into effect in 30 days. So it's
Or let them resolve in this meeting?
Well, we don't have to vote, we just have to.
I'm proposing a change of the regs that owner doesn't have to store for 60 days.
That sounds great.
Just
I
to
agree
cross
with
that out.
This is what I'm saying. That would-
To cross that out, but to add that the loft board will notify tenants of the dangers
Yeah.
associated with
I think
this.
that's reasonable.
Yeah.
So what would happen if something was identified in the fire egress pass? How the owner would be in 10 days? After this restriction, remove when that's what it is. That's a department of 6 days that they was over.
Well, one could argue that 10 days is not enough time. And we're at it now. It is longer than 2 weeks. If that's typical.
could notify tenants, you know, and at the end of it say, and if you do leave things in the hallway, and they're still in the hallway 30 days from now, or whatever, and next days from now, the owner has the authority to remove them, and goodbye to the item. The owner is not obliged to destroy the item.
We've added an extra step in there, which is the loft board, notifying them. The rule says the owner themselves make those notification, correct?
Right, no, the notice comes from the owner. The loft board, prior to the effective date of this rule, will send out that says, this is now going to order, this is now, maybe immediately after its effective date, will send out a notice, this is now a loft board rule. You cannot store particular items in any public hallway, public entrance, public stairwell. That's just a one-time mailing sent to every IMD unit to sort of give notice to the community. But if there's a particular problem in a particular building, the owner has to take action in that building against those items that are violated.
So the only time that we would issue a violation, or a violation would be issued by anyone, would be in the event that there's an inspection of some sort, either a DOP inspection or somebody calls and reports that, or law board inspection.
Just one more thing. At no point have I read anywhere that we said any object in the hall, including a little rug in front of the, without a rug in front of the door. That's also illegal? Right. Yeah? Right, okay, but I don't know whether that's clear enough for everybody, that's all I'm saying. Sure, trip falling down the stairs, it was, this, it's a fire, that's, that's jokes.
Storage of items in the pathway, IMD versus It's on page 4. Slowly to the middle,
This is just all.
see it?
Mine doesn't have it.
Yeah, it does. It's on page 4. Capital D,
Yeah.
the last sentence in D.
Oh, indeed.
D as in dad.
I just needed to be in what? Yeah, I was just looking at the wrong paragraph, thank you. I also.
No, I would just say, in that section, the owner may remove the items from the category period. You know, and the notice would be coming from the law board before the next meeting are finalized, warning tenants that if you store items in the hallway, they could be removed. See, not every tenant, I'm sure, I haven't seen a tenant's commercial lease in a while, but I don't think everybody has a commercial lease like yours that makes things so clear. You know, so I think the loft board has to make it clear.
Sure. Yeah, we're all in agreement on that point. I think that question on the table is, are we good with changing it from 10 days to 30 days and removing the reference to the building owner being required to store the items.
There's nothing indirect about owners being required to store items. It's implied that the...
Right, so we remove the 60-day part of it.
And they discard any remaining items, period.
Is there a second on that motion?
Second.
Thank you, Ms. Redon.
Can we be clear exactly what we're doing here?
The owner is responsible for removal of any items stored in violation of paragraph A and may discard items.
In sections B and D of 3 little I, correct?
On page 4.
On page 4, right. B as a boy. A says no storage of items. B as a boy says, the owner is responsible for removal of any items stored in violation of A and above, and may discard items that have violation of A and above.
No, it says and it says the owner must serve a 10-day notice on tenant prior to removal of the items.
Did you say that's condition 30?
Correct.
In subparagraph B, the 10 days should be 30 days.
Yes.
I'm sorry, it's a reference to 10-day notice section. Yes.
Yes,
It's talking about changing the law.
correct. And in D,
And
as
D.
in David.
And D, we're removing that whole sentence. Oh,
But
you're
if-
right. Yeah, I'm sorry. Sure. The owner may remove the items from the pathway after 30 days and discard them.
Yeah, it's
That way
almost,
it wasn't-
it's almost as if the first sentence of paragraph D, as in David, should be part of paragraph C, that's about notice. And then the paragraph about the owner having the right to remove the items after 30 days is its own paragraph.
Okay. The owner may remove the items from the pathway after 30 days. 30 days from the pathway, 30 days after service is deemed complete, and may discard any remaining items.
The problem with that is the owner gives a 30-day notice, right? And on February 1 and on February 10th, there's a fire and the item hasn't been removed.
understand for clarity. Is the intent of this safety or convenience? Because if it's about safety, then I'm gonna jeopardize safety because somebody's on vacation.
Yeah,
But
that's what I'm
I'm a
saying.
little confused about it. I
But,
understand
all
the
right,
point.
take vacation off, like your dad dies,
So we have
or,
vacation to death, okay.
but yeah, I mean, so you've made a mistake, you've left something in the hall, you have a family emergency, you come back and your favorite 18 or whatever, it's gone. It is. I get where you're coming from, but it also seems a little.
The question I'm trying to get at is, I'm not necessarily suggesting that we shorten the period for storing the item. I'm just saying, if the whole purpose of this is to address safety, and someone's circumstance doesn't lend for an immediate addressing of the safety concern, so that others may be in jeopardy, is there a possibility of just having the owner, through whoever represented, whatever body serves as a representative, just move it out of the way so safety is not happening?
So that's how it's written, that there's a notice period, which is very short. It's basically the time it would take to serve, because you have to be served by now, like the time it would take to serve someone. And then the building owner or its representative removes the item, but keeps it for a longer period of time in case there's extenuating circumstances. So that's what it says.
That's what I'm comfortable with, that's what I'm asking.
Do you think we shouldn't change it?
Yeah, I don't, because I don't think we should change it as long as we understand what the intent is. If the intent is about safety, then when do you have time other than the immediacy to address the safety concern? If it's not about safety, then I'm all for everything that's been done.
And so the question that's been brought up is, what if, or that if the onus is on the building owner to store someone's personal property for a year, 45 or 60 days or whatever we decide the timeline is, right? Which is a burden for them. But also, then there's the question of where do they store it? How do they store it? What if it's damaged? It kind of opens up
Well,
We can't let perfect get in the way, but
I mean, most of these buildings, I mean, outside of a couple of those enormous buildings in Brooklyn, are 4, 5, and 6 stories. They're not huge buildings, they're not apartment buildings with 30, 40. So there's a basement. And I would presume that the owner or the owner representative would take the stuff and put it into the basement. 60 days seems to be a reasonable amount of time, because as you might say, the tenant may be gone for a couple of weeks or so. So throwing it out doesn't seem to make good sense, but it would be put into the basement. Where else would it go? On the roof?
Well, then maybe the point would be if landlord does that, if owner does that, owner's not responsible if some third party takes it out of the basement and appropriates it,
Well, then that's too bad, right?
yeah, something like that, that gets, I don't want the owner to be responsible for the security of the item. They could be expensive items. So maybe leaving it as it is and as it's written and adding something about that would be a route.
Much as I was hoping we could get this rule done today, I think between the issues raised in the room and the, whatever they're doing outside, it's probably going to have to wait until next month to get cleaned up.
I would think that we should table this just because of that noise. It's just driving me crazy.
Okay.
I have a few questions on other aspects of it, but But I think that suggestion that the owner is expected to store it, but is relieved of liability makes
Yeah, absolutely.
all the sense in the world.
Okay, yeah, I would go with that.
Also, on this piece, when you were describing it, you used the word hallway. But hallway does not appear here, other than implicit. Is that something you gave thought to, or?
No, I was just thinking hallway.
Yeah.
That was one of my,
Yeah.
I actually have several definition comments, and that was one of them that, since we're on page 4, it says, we're using the term pathway for fire egress. And I don't want to, did you have more?
No, I'm just nodding.
All right.
In agreement.
Pathway for fire egress, which is not defined, but we also don't include corridor, which in the building code is a defined term of, at least in the 69, an enclosed public passage providing a means of access from rooms or spaces to an exit. Because as we're discussing, I agree 100%, we keep, the rule and the discussion includes the corridors, but it's not actually in the rule. The rule is just the stair and the fire escape. So that's an oversight. Yes.
Well, what is that area called? If you have a back stairway, you open up your door, and the stairs don't, wide is not at the door, there's a little area there. Would you call that a hallway?
No.
What would you call it?
Hallway is not a technical term.
Okay, so what is it called? What is that
It's called
area?
corridor
The corridor.
or a vestibule.
Well, would be a vestibule on the upper floor? Is that a legal proper term?
I don't know if there's I don't know where the delineation between vestibule and corridor. So the way that egress works in the building code, at least, is that it says you need to have an interstitial space between the occupied space and the vertical egress, which is the stair. So you need to have a door and an interstitial space. And that can be either a corridor or a vestibule, or, but corridor is the defined term in the building code. So even if it's only 5 feet long, it's still a corridor.
Okay,
And a hall is within your apartment.
okay.
So a corridor is a fire-rated enclosure
Okay,
that allows you to egress the building safely.
okay, that's not clear. I hope.
We will add a definition of corridor to the definition section.
Oh,
But I do not think it's a good idea to talk about fire rating, because that's legalization work.
Yes,
So-
I thought that comment, that response was smart.
So we're going to leave the onus on the owner to store stuff for a period of time.
Yes.
Okay. So going back to page 2, got a few questions I think. You remove structural adequacy. Is there a reason for that?
Yeah, the discussion, the comment that I made at the very beginning, the idea behind this rule wasn't that you would have to go out and get a structural engineer. That what we really wanted is that there would be some inspection of the fire space, fire stair, to make sure that the stairwell is safe and it's lit and it has railings, that there's no defect.
So the owner can do that himself or herself. Or they can have the super do it. And we will create a form that's part of the renewal package.
Yes.
That will explain I did it or my
Yes.
super did it. So we'll have somebody on the hook for it.
Yes.
Okay. Then we've beaten page 4 to death. Page 5, little 4 IV, the law board may request an inspection report by registered. So it's when we ask for an engineer to inspect, which we have the right to do. Owner must file the report within 30 days of the request, or what?
You would issue a violation?
Okay, we would issue a violation. And that would be the violation of failure to maintain fire egress?
Yes.
Okay. All right. And again, on page 6, annual certification requirement. If defects are found during the annual inspection, owner must certify the law board that defects exist and repairs will be completed on or before August 1st. And if they aren't, then it would be the same violation. Is that correct?
Yes.
Okay. And then finally, second to finally, with regard to the applications that we're due on July 1st this year, how are we going to notify the owners? Then my last comment is still, I think this is a very important change for the board. 100% support. In your testimony, that maybe the $5,000 fine amount should be higher. And again, safety, we've seen a lot of owners doing a lot of fines. I would suggest we consider making a higher amount and give that thought.
Now, I'm going to check with the fines
Shades it back again. I want to sticky. Let's say there's a long building, this door, there's no elevator. Where is the right? And there's a delivery. Delivery's put into the vestibule. Then what? Is that legal or not legal?
That's a very good question. It's, I guess, technically not.
last building I was in, their mailboxes were not at the entrance. The vast majority of IMPs, when you come in, the mailboxes, if they have mailboxes, are right in that area when you come in, and there's usually a platform there. That is not but there's a platform there where I've seen mailboxes. But there is still clear passageway to walk in and walk up the stairs or walk wherever you're going. I don't think that those shelving are is captured in this rule. It's not obstructing the ability to go in and out and or run in and out. It's an emergency.
Elliot, yes, I will agree that a male, you be allowed to have a nook or something, right, for, as long as you have the clear, whatever required,
shortage of items, and a package that was delivered on that day, it's not, it's there, but it's not being stored there. It's not
No, I have a few more. Just, hopefully these are a lot less of a discussion. So some of the definitions, same like, the idea about the difference between a hallway and a corridor, how a lot of times more common terms, they're not technical terms. So, understand our relationships with multiple dwelling law, the housing maintenance code, the building code, right? And try to follow suit. I was thinking it would be an easy task and that I would look up all these definitions and they would all match, and of course they don't. So but I did compile and I emailed this to Martha. So it's definitions from the multiple dwelling law, the housing maintenance code, the 1969 building code, the 2022 building code, and the zoning resolution. And so fire escape is defined, what we have is fire stairway. That's not a term that any of the other codes use. It could be a fire stair. Oftentimes it's just a stair and corridor. Also, the building code doesn't refer to it as fire egress, it just refers to it as egress. It could be any kind of emergency. One of my comments for section 1, section 2, paragraph it says, in the case of an emergency, I would argue it should be in the event of an emergency.
I thought we should just say that. In the case of emergency or anything like that, it doesn't matter. The point is that it's egress.
Right.
It doesn't matter whether it's an emergency or not. You should be able to go in and out of the building
Safely.
Exactly. So let's take that.
Okay. Should I explain more, or just my thoughts? Does that suffice? I don't really have a specific, like, I think we should, for instance, at the very least, instead of fire stairway, it should just be fire stair. Or egress stair. And then same with triple lower I. It's the path for fire egress. So that should either be the path of egress, which would include the corridor, the stair, the lobby, and all of it, or differentiate when we're talking about corridor.
So why personal property?
Yes, this personal property stored in the pathway line of fire egress, which is not a thing, it's the path of egress. So, I can make it pass through it, or I can just leave it in your capable hands. With the preliminary work that I did last night. That's it.
Just one other note. I noticed from the testimony, we had a couple buildings that said there are egress issues in my building. I just wanted to follow up. 151 and 5.
This is our case agenda. There's 3 cases on the summary calendar. We usually vote on these cases as a block. This is on 135 Manhattan Development, docket number LI-059. Order for that case is being amended as follows. We're clarifying the first sentence of the order. We're referring to C2, C6. Revised sentence will be on July 18, 2023. Assessment C2, Melissa Loft and Benavides of Unit 6, C6, and Drew McDowell of Units C3 of 135, 141 Kent Avenue, Brooklyn, New York. Building filed an application seeking finding of unreasonable interference against 135 Kent LLC, the owner of the building. We're also revising the third sentence to clarify that we're referring to units C6 and C3. So the revised sentence will read in the stipulation of settlement dated March 4, 2024. Melissa Locker, Brian Benavides, and Drew McDowell discontinued or withdrew with prejudice unreasonable interference made in units C6 and C3. The next case on the summary calendar is 187 Wade Street, New York, docket number TN0235. Third case on the summary calendar is 142 Broadway, New York, docket number TR1478. No presentation for the summary cases. Are there any comments on these cases? Is there a motion to accept these cases? Thank you, Mr. Bowers. Is there a second? Thank you, Mr. Mayor, can you please poll the board members?
Mr. Beckman?
Yeah.
Mr. Bradley?
Yes.
Mr. Vaughn? Mr. Delaney?
Yeah.
Mr. Singleton?
Yes.
Ms. Verdon? Yes.
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 7 in favor, 1 abstention.
Thank you. We now turn to on the cases on the master calendar. There's 3 cases on the master calendar today. The first case is 49 Charlton Street in Brooklyn. Docket numbers LI-0048, LI-0049, TM-0103, and TM-0106. We're also amending the order associated with this case. Page 4 of the order. The second to last paragraph, we're revising the first sentence to read as follows. Tenant contended that owner unreasonably interfered with the use of his unit when owner installed a big enclosure with a mechanical exhaust duct in his bathroom. The soffit which lowered the ceiling to about 8 feet and boxed out a vertical ductwork of about 11-inch portion of the space behind the bathroom door. We're replacing the word with the word to in that sentence. Mr. Yeager will present on this case.
Thank you, Chairperson Katsina. This is a tenant's application. The applications include the diminution of services and unreasonable interference claims. In the diminution of services application, tenant asserted that owner diminished services relating to his access to the parking lot, access to the rear entrance to the building, a change in the location of the south entrance to the building, and security entrance to the building. The unreasonable interference application alleges that owner unreasonably interfered with his use of the unit when owner installed an enclosure for the mechanical exhaust dust in his bathroom, a surface which lowered the ceiling width and burst out a vertical dust of 11-inch deep portion of the space behind the bathroom. Tenant further alleged unreasonable interference when owner painted over original details in the wall, painted the radiator, installed mismatched tiles in his bathroom, sanded the floor, and also pulling on his floor. Section 204C of the Title 29 of the Rules of the New York City of New York, requires no diminution of services. During trial, tenant was able to prove prior use of the parking lot as well as access to the statute door for access to the rear entrance into the building between the period of 2001 to 2013, with the permission of the owner on the first come, first served basis. For the unreasonable interference claim, tenant demonstrated that installation of the soffit and the vertical duct work by owner resulted in a loss of space in his unit, but failed to explain why the loss of space was unreasonable. The loss was related to mechanization work. The proposed order grants the diminution of services claim to the extent of tenant access to the parking lot and access to the rear door from the parking lot, and denied the unreasonable interference claim. Any questions? Thank you.
Is there a motion to accept this case? Thank you, Mr. John. Is there a second? Thank you, Mrs. Singletary. Ms. Rivera, can you please pull the board members?
Ms. Becker, please.
Yes.
Mr. Barrett,
Yes.
Mr. Wong, Mr. Delaney,
Yes.
Mrs. Singletary,
Yes.
Ms. Rajan. Yes. Ms. Rosen,
Yes.
Chairperson Patino.
Yes.
7 in favor, 1 abstain.
Thank you. Next case on the master calendar is 950 Hart Street in Brooklyn. Docket numbers PO0108 and TA0261. Ms. Story will present this case.
Stephanie Lynn filed a protected occupancy and rent overcharge claim. In his answer, the owner argued that Ms. Lynn's unit was not subject to rent regulation due to a prior sales of rights pursuant to MDL Section 28612. These claims were transferred to Oath for adjudication. Oath issued a report and recommendation finding that Ms. Lynn's protected occupancy status and rent overcharge claims should be denied. The pivotal issue in this case is whether the transaction between the prior owner and the prior tenants constitute an Article 7C sale of rights. To demonstrate a valid sale occurring, there must be proof of an intentional relinquishment of a known right and valid consideration. Here, the prior tenants did not testify, nor were any affidavits produced at trial. Ms. Lynn testified that in a telephone conversation, the prior tenants informed her that they did not knowingly sell their rights and they did not receive compensation. Owner produced the prior tenants' signed sales form, the pro se coverage claim that won the prior tenant's protected occupancy status, and a witness with first-hand knowledge along with unsigned letters to corroborate the testimony. Owner's witness, the prior owner's attorney, testified that the prior tenants owed more than $7,000 in rent arrears. The owner agreed to apply the security deposit plus an additional $1,700 credit to the rent arrears in exchange for the prior tenants selling their Article 7C rights, remitting a check for the outstanding rent, and providing their keys to the unit. The preponderance of the evidence supports owner's narrative. Therefore, the proposed order before you today dismisses Ms. Lynn's claim.
Are there any comments on this case?
Yes, as I stated when this case first came before us in June, I plan to vote no. I don't feel that the owner has proved his case. I think the amount of alleged compensation doesn't rise to the level that would make it a 286-12 sale. I think a better alternative would be to send this case back to oath and attempt to have further fact-finding.
Thank you. Does anyone else have comments? Is there a motion to accept this case? Thank you, Mr. Singletary. Is there a second? Thank you, Ms. Rosland. Ms. Rivera, can you please poll the board members?
Ms. Grayson Lee,
Yes.
Mr. Bauer,
Abstain.
Mr. Wong,
Abstain.
Mr. Delaney,
No.
Mr. Singletary,
Abstain.
Ms. Brajon,
Yes.
Ms. Roseland,
Yes.
Jefferson Patino,
Yes.
4 in favor, 2 abstain, 3 abstain, and 1 against.
Thank you. The last case on the master calendar is a removal case. It's 33 Union Square West in New York, docket number LE0393. And the proposed order for this case is also being amended. The last sentence on the first page of the order is being revised to read as follows. The initial registration application listed a total of 16 residential units, 1 residential unit on each of the 4th, 6th, and 11th floors, 2 residential units on the 5th, 7th, 8th, 9th, and 10th floors, and 3 residential units on the 3rd floor. The first sentence on the second page of the order is being revised to read as follows. Thereafter, on June 22nd, 2011, owner registered 1 residential unit on the 2nd floor. Little I under B, rent regulatory status of the IMD units is being revised to clarify that 2 units were combined. So 3M and 3R are being combined, so the sentence will read units 2F, 3F, 3M/3R, 4F, 5M, 7F, 7R, 8F, 9R, 9F, 10F, 10R, and 11 penthouse are not subject to rent regulation pursuant to Article 7C. The chart identifying the unit numbers, tenants, and date of sale is also being revised. So for unit number 8F, we're adding 805 next to it to clarify what the unit number is. And then the sentence that follows underneath the chart is being revised to read as follows. Consequently, pursuant to 29 RCNY Section 210 D2, the law court finds that solely with respect to Article 7C, units 2F, 3F, 3R, 3M, 4F, 5M, 7F, 7R/708, 8F, and 9F, 9R/906, 10F/1001, 10R/1007, and 11 penthouse are not subject to our regulation. Are there any comments on this case? Is there a motion to accept this removal case? Thank you, Mr. John. Is there a second? Thank you, Mr. Bowers. Ms. Rivera, can you please pull the board members?
Mr. Ray, Ms. Bristol,
Yes.
Mr. Barrett,
Yes.
Mr. Vaughn,
Abstain.
Mr. Delaney,
Yes.
Mr. Singletary,
Yes.
Ms. Brajon,
Yes.
Ms. Roseland,
Yes.
Jefferson Patino.
Yes.
7 in favor, 1 abstain.
Thank you. So that will conclude our September 19, 2024 public meeting. Our next public meeting will be on October 17, 2024. Board members, please sign and submit your attendance sheets. Thank you, everyone.